Domestic workers, or as I like to call them, home executives, need more time to claim for work injuries. This is the plea from unions. Unions are saying that the November 20 cutoff date is too short. Attorney Thulani Nkosi from the Socio-Economic Rights Institute joins us now to discuss this a bit further. A very good afternoon to you, Thulani, and thank you so much for your time. So when it's said that the time for claims is too short, what do we mean by too short?
Okay, so what happened, Mrena, is that when domestic workers won in the Constitutional Court, two things happened. The first was that they would be included in COIDA, but the second, it was that the order of the Constitutional Court was to have what's called a retrospective effect from the 27th of April, 1994. So what has happened since then is that the Compensation Commissioner has gazetted what he calls rules to register domestic workers' employers. So part of the rules is gazetted is a rule that says that for retrospective claims, domestic workers must bring retrospective claims within 12 months from the Constitutional Court judgment last year. So that is the part that you are saying is too short.
Talk to me about exactly what it is that is being claimed here. I mean, obviously, there are different varying claims from domestic workers, and one of those, of course, would be that they be recognized by the employers as actual employees and be, I would imagine, registered and get things like benefits, the UIF and such. But what exactly is an attorney such as yourself fighting for domestic workers for?
So for the longest possible time, domestic workers were not covered by the Prison Diseases Act, which meant that if domestic workers were met with an injury at the workplace, or indeed sometimes, so that was the case happened, and it went all the way to the Constitutional Court. And the reason why domestic workers were not covered, it was because that category of workers was specifically excluded from COIDA. So as I say, when the matter eventually went to the Constitutional Court, that part of the section was declared to be unconstitutional because there was no rational basis for the exclusion of domestic workers, because as we live in this country, everybody who meets with an accident at the workplace has the possibility of actually claiming from COIDA, because COIDA is what we call a social legislation. So now that part is not necessarily the biggest issue now, because the COIDA has agreed that it's going to amend the law and domestic workers will be covered. The only problem that is playing itself now, it's because of that retrospective effect, because what that meant, it meant that domestic workers who had met with injuries as far back as in 1994 can actually prosecute those claims today. So the Compensation Commissioner then says, insofar as that part of the order is concerned, all domestic workers who have been historically excluded from 1994, they've got 12 months to bring their claims, failing which their claims would prescribe.
Thulani, here's a question that I've always been interested in having answered is, I have a home executive. That's what I say I prefer to call them. I have a home executive that I've had in my employ for about 3 years, and they're not registered anywhere. So they're not, able to claim for the UIFs and claim for these kinds of injury compensations. How then do you keep track of such home executives? How do you know that Morena has a home executive in his house and needs to be looked after, but they're not registered?
It's going to be a problem because insofar as the UIF is concerned, domestic workers are covered by UIF and they've been covered for a very long time. But the problem, as you say, is that, and I don't really know what causes this, because what needs to happen is employers must register their employees, be it for UIF and for COIDA now. So what we have got a situation where there has been a very low registration rate by employers of domestic workers. And that is why the UIF sometimes does not even work for domestic workers, because you are met with the same problems that they've been working, but the employers, because remember the responsibility to register rests on the employer. And if the employers are not obliging, both the UIF and COIDA, they've got enforcement mechanisms, but for one reason or the other, they've not been able to really deal with this situation insofar as it comes to domestic workers in particular.
Okay, so some employers might be watching this interview and watching this conversation between you and myself and would actually want to do right by their home executives and want to register them. How then do they go about doing that? Do you know that information?
Yes, it's simple. There are two ways. One would be, to go to the Department of Labor. There are forms there that will be given, and you'll complete those forms, put the details, and you are registered. So in this instance, you'll get two sets of forms. You'll get the first form for UIF if you've not registered with domestic worker for UIF, and you'll get the second set of forms for COIDA if you haven't registered your domestic workers for COIDA. And the second way, I'm told, I haven't really checked this out, is that you now can also do it online. If you just go to the Department of Labor's website, you are going to get these forms to complete online and submit. It's as simple as that to get the registration going.